When you think about law school, you probably picture learning the law, right? But it's so much more than that. It's this intense, high-pressure process that's literally designed to change how you think, to forge a whole new kind of mind. But you have to wonder, what's the real price of that transformation?
All right, so here's how we're going to break this down. First, we'll tackle a really interesting paradox at the heart of it all. Then, we'll get into how law school literally rewires your brain. From there, we'll define this thing called the adversarial mindset. Look at the good and the bad of it, the whole double-edged sword, and finally, we'll explore some new ideas for how legal training could be different.
All right, first up, the law school paradox. And this is a really startling contradiction, one that gets right to the core of what legal education is all about.
And take a look at this quote. Law school promoted feelings of insecurity, inefficacy, and isolation. I mean, wow. And the thing is, this isn't some rare complaint. This comes from a real student talking to faculty, and it captures a feeling that is surprisingly common and, frankly, pretty troubling for a lot of people.
And look, this isn't just about feelings or anecdotes. We're talking about decades of research here. Study after study, from the US to Australia, confirms it. Law students suffer from psychological distress. We're talking depression, anxiety, at rates that are way, way higher than their peers in other fields or even the general population.
So that brings us to a huge question, right? Why? Why does training for a profession that's all about justice and fairness seem to create so much personal distress? It just doesn't add up.
Well, the answer, it turns out, isn't just about the long hours or the heavy reading. It's something much deeper. Law school is actually, and very deliberately, designed to perform a kind of cognitive surgery. It's meant to fundamentally rewire your brain.
So in psychology, there's this idea that we all have two main ways of thinking. You've got your rational thinking, that's the analytical, logical, step-by-step part of your brain, and then you have your experiential thinking, which is more intuitive, gut-feeling, emotion-based. Now what law school does is it takes one of these, the rational side, and puts it on a pedestal, often at the expense of the other.
And you can actually see this happen. Check out this data. Researchers track students through their very first year of law school. And what did they find? A big jump in rational thinking. No surprise there. But here's the kicker. At the exact same time, their experiential, intuitive thinking took a nosedive. It's a trade-off.
And make no mistake, this shift doesn't just happen by accident. Oh no, it is engineered. It's baked into the very teaching methods that have been the bedrock of legal education for more than 100 years.
Take a classic example, the IRAC method. If you've been to law school, you know this one. It stands for Issue, Rule, Application, Conclusion. And it's drilled into you from day one. It's a really powerful framework for logical thinking, for sure, but it also forces your brain down this very rigid, linear path. And in the process, it tends to strip away all the messy stuff, like emotions, personal morality, or just plain old intuition.
Okay, so we're seeing this shift towards pure logic. But this does more than just change how you solve a problem on a test. It actually forges a whole new mindset, a really specific and strategic way of looking at, well, everything.
And what's crazy is how much this new mindset starts to look like ancient military strategy. I mean, listen to this quote from Sun Tzu's The Art of War. Scheme so as to discover his plan and the likelihood of success. You could put that on the wall of any top litigation firm. It's all about figuring out your opponent's plan so you can take it apart. This gets to the heart of what some cognitive scientists call adversarial problem solving, and it's a huge concept. It means you approach a problem not as a collaborative search for the truth, but as a strategic battle. The goal isn't necessarily to be right, it's to win by predicting and foiling your opponent's every move.
And to do that, you have to become a mastermind reader. You have to build a complete mental model of your opponent. What are their goals? What do they believe about the situation? And maybe most important of all, what do they believe about you? It's like playing chess, but with arguments. You're constantly running a simulation of their brain to stay 3 steps ahead. So this adversarial mindset is, without a doubt, a super powerful tool. But it's a classic double-edged sword. It comes with some pretty serious consequences.
On the one hand, let's be honest, it works. This training creates incredibly effective, even formidable advocates. We're talking about people who are masters of logic, who can see a counter-argument coming from a mile away and who can just own the narrative with total clarity and poise. These are the skills that win cases, period.
But on the other hand, that sword cuts deep.
That constant, high-stakes, me versus you focus is directly tied to all that psychological distress we talked about at the beginning. It can push empathy to the back burner, and some critics even worry that it freezes legal imaginations, that it stifles the very creativity you need to think up better, more just solutions. And here's a perfect, if heartbreaking example of how this happens. There's a famous case about the Coconut Grove fire in 1942. It was a horrific tragedy, a fire that killed almost 500 people. But in law school, that event, all that human loss, gets boiled down to an abstract legal concept, involuntary manslaughter. The real human story gets flattened into a logical puzzle.
So because of this high cost, both personal and professional, there's a growing movement saying, hey, maybe we need to rethink this. There's a real call for reform in how we train lawyers.
And this question from a student just gets right to the heart of it. As emerging lawyers, do we have an opportunity to change things? That's the whole spirit of this movement. It's not about throwing out the analytical rigor, it's about figuring out how to keep that, but without all the damaging side effects.
So what would that change look like? Well, one really interesting idea is something called the contextual case method. Right now, students usually just read the judge's final opinion, which is all neat and tidy. But with this new method, they'd get the whole messy story, the original court filings, the witness testimonies, all of it. It brings back the conflicting human realities that the final judgment often smooths over.
And it's not just about teaching methods. People are pushing for bigger cultural changes too. Things like, more positive and useful feedback, not just tearing arguments down. More transparency about what's expected. More chances to actually work together and feel less isolated. And, this is a big one, actually prioritizing skills like empathy and conflict management, not just how to win a debate.
So all of this really leaves us with one big final question. What is the point of a legal education? Is the goal to forge the sharpest possible weapon for the courtroom? Or is it to cultivate the wisest, most empathetic counsel we can? Maybe the real challenge for the future of law isn't choosing one or the other, but figuring out, finally, how to achieve both.